applicant's dispute is with the Human Rights Commission functioning under the guise of the 1990 New Zealand Bill of Rights Act and others, because I said the Crown has failed, neglected in their duty to strike out the Human Rights Commission and other charters and declarations on the same premise, in that they do not identify their declarations with sufficient particularity. Do you understand that?
Yeah.
The United Nations Charter, their UNDRIP, their refugee laws, the human, all that, none of it is particular.
Yeah.
So, and since they're not particular, they should not be allowed into New Zealand law. And why are they even allowing it in the courts? Because we can't fight them. So we're saying that. And then he says, here at the best one of all, 6 declarations that the court cannot grant. And look, the applicant's dispute counsel, and that the court, I've repeated it, the court's going to grant this, applicant's dispute counsel that the court cannot grant a declaration vindicating and insisting upon all and the singular premise by whole declaration based on successive precedent in New Zealand law. So we've shown, or I better put that, as above to prop 3.1. So the applicant's dispute, because of the 5 document declarations that the court has already issued, why aren't they allowed to issue them anymore? What happened? Yeah, they're still in law. And so, so why doesn't the judge have the power to grant a whole document when they've already done it 5 times?
That's right.
So why can't they do it again, a 6th time, with the Sixtus? I'm the 6th Pope. And that's true, I am the 6th Pope. Applicants agree that there is dispute in Lexis regarding, Lexis is talking about wording that relates to a group of words together to create a meaning that have a specific meaning in that groups of words. So the applicants agree that there is a dispute of Lexis regarding Her Majesty Queen Elizabeth II of the United Kingdom and Ireland. He's saying that we can't ask for a grant using the words Her Majesty of the United Kingdom and Ireland. He's saying we can only use Queen. We've said the applicants encourage the High Court to ponder about this. So we're asking them to think about it. And we ask the court to refer the 1975 Treaty of Waitangi Act, which has the recognised English version of the treaty, which uses Her Majesty of the United Kingdom and Ireland. There, yes. So I'm saying, let the court think about that. And I've said the 1988 Imperial Laws, Will and Mary, also says Her Majesty Queen Elizabeth, because she was ascended, they ascended her.
Yeah.
Of the United Kingdom and Ireland. It's in the 1988 Imperial Laws of New Zealand. So I said to the judge, will you go and think about what he's just said to you, Judge? So that was the asking for the initial declaration that we want to establish our power base. And right. Then we will have our arms. We'll have back our arms because they have disarmed us. Now this comes under the standing army. That the raising and keeping of a standing army within the kingdom of time of peace, unless it be with consent of Parliament, they're trying to get Parliament to consent to raise a standing army. And it's against the law.
Hang on.
This is what the United Nations, yes.
They are trying to get Parliament to raise a standing army.
Yes. The United Nations is against us. So Parliament has to consent.
Because the world's largest standing army is in America. And
listen, stop it. You're not understanding standing army. It doesn't have to mean guns and bombs and soldiers. The arm of the law, the chamber of hewn stone is an arm of the law that you can use to battle in legal terms. When you have a democracy, you should not be battling with guns. You battle by the use of Parliament and the court. That's how you do battle. And that is the army that you use. The law is your army, the law. It can also be used as a weapon against you. And they're using their laws as a weapon against you. And they have told you that you have no weapons. And they are wrong. So when the United Nations brings in the Declaration of Human Rights, the Declaration of the Charter of all of those, that's raising a standing army in law against you for no reason. All right? So in order to raise this standing army, they first must create chaos. Because it says here, in a time of peace, they can't do it. So they need times of war so that they're able to do that.
Huh?
Yes, you see? So then it comes, but here's the next right. Subjects' arms. The subjects which are Protestants may have arms for their defence, suitable to their conditions and as allowed by law. Well, this is our arm of defence in law.
Our arm of defence in law is our Declaration of Right.
Yes. And they're trying to, so we need to re-establish, because since they've been raising a standing army against us, we need to apply to the court to give us back our arms, because they've illegally removed our arms. And we are asking for a return of our arms of defence in law. So that's what we're asking for. Yes. So that's why I said to the court that that we're asking for
our arms back.
Our arms back. And so so we said that, where did I say that? Did I ask for our legal arms?
Yes. Well, I would say, other than legal arms, I would say, can we have our legal arm?
Yeah, I've got arm, A-R-M.
Yeah.
I said, no, I said legal arm of the Chamber of Hume.
Yeah.
The Chamber of Hume is the court of law that was built with a special kind of stone from the Canaan Mountains. New Zealand's Canaan Mountains are in the South Island. And the court was built by that. And it's called the Chamber of Hume, and it's your arm of defence. It's steel, it's your arm of defence, it's a sword. It's a court that has been made with the edge of a sword, which means that your arm is no longer going to be a sword, your arm is going to be the law. And so that's how you became a democracy and not chop everybody's head off with your sword. So they gave us a different set of arms, and now they're trying to remove them. And we're saying, well, no, because then we'll have the right to stand up and attack you with our swords, won't we?
Yes.
Because they've taken away our arms and they're not allowed to. So that's what we'll have to say in the court. And I will explain that in the court.
You might even have to explain that to the judge.
Yes, I will.
He probably doesn't even know that.
I don't know. Let's see.
Yeah.
We'll ask it. I will ask him if I may have 5 minutes to explain myself, because I have more confidence now.
Yeah.
So I'll ask him for 5 minutes to explain myself.
I would do that. That's a very good, very, very, very good way to open his mind up, and that he's bound to be able to see what's been going on here in New Zealand, and by explaining what you just explained to me to him, he will be doing justice by giving giving people back our power.
Yes. We are asking for our power back.
Yeah.
It has been taken from us for 30 years.
Yes. By the
we're asking for it back.
Yeah.
Because we're saying that we can't cope anymore.
Yes.
And once we have it, we'll have a lot of power. A lot. So much power. You have no idea how much power you're going to have. It's just going to be phenomenal. And so then I said in the second prayer,